today's lecture is Women's Special Lecture and Manisha Sharma is with us. And today's lecture deals with gender justice and law. Gender justice has been subject of discussion at national and international level, and the concept of gender injustice is a common phenomena in the modern world. It exposes discrimination, oppression, subordination, domination, the bias in the treatment of men, women, transgender, dignity, workplace, role in the family, society, religion, etc. So, gender inequality occurs when the people treated differently based on their gender status. Women have always been considered the weaker sex due to the physical, mental and the economical restraint. So, in a society dominated by men, women have historically been viewed as a second-class citizen and face many oppression. Although the progress has been made in the recent decade and the fight for gender equality and gender justice remains a significant challenge. So, the objective of the today's session is we will try to comprehend the status of the women in the Indian society through the years. So, the people generally, and I also felt the same decades ago, that the gender, it relates with the equal right, maintenance, marriage, divorce, domestic violence, etc. But gender is much more than that. So, what I propose to discuss in today's session, to discuss the history prior to the constitution and after the constitution. So, both these era give rise to the significant legislation, and also judiciary played a very important role pertaining to gender. So, when the Britishers, they came over to India for the purpose of trade, so there was no law. So, the Britishers, they were not interested in interfering with their custom, but they want to have a law, and they also felt that the condition of the women is not as good as in England. So, therefore, they tried to codify the law, and Macaulay was sent to India for the codification of the law. So therefore, the law which was pertaining to the criminal code, it was drafted, and that law became the basis of the Indian criminal law. As the Macaulay saw the position is not secured as in England, so therefore certain laws for the women and the children, they were drafted, and certain provision for the protection and in the favor of the children, they were also incorporated. So therefore, Section 292 is one of the example which basically deals with the pornography. So, the pornography was dealing with the selling, hiring, publishing and distributing of any book, pamphlet or paper if it is lasciviously. So therefore, it also provides the punishment for the same. And similarly, Section 354A was also introduced, which deals with the outraging the modesty of the women, and it also provides certain liabilities to a person who exhibit pornographic content to any women against her will, and it also provides the punishment for the imprisonment of 5 years or with fine. So at that time, during that time, the miscarriage was not allowed to take voluntarily. So, Section 312 was introduced, which restricted the scope and allowed the abortion only to save the life of the women. Female infanticide, female feticide, they were also officially recorded, and they were also discovered by the British rule in the year 1789. And so, therefore, this act came into the existence, and it was declared illegal. Female infanticide was declared illegal in the year 1804 by the Regulation 3. And this regulation deemed female infanticide as murder, and thus also provides the punishment for the same. Although the act was introduced, further the act was also amended in the year 1897, but this act did not stop the infanticide of especially the girl children. Then further, for the favor of the women and the children, another provision was introduced pertaining to abandonment of the child. So if you look at the provision, on the face of this provision looks gender equal, but it did not happen. Rather, it was gender discriminatory. In reality, the girl child, they were abandoned, and the child begotten due to the rape, they were also abandoned. So therefore, if we look at the provision, and there was another very, very important provision, as we know that recently the Supreme Court has decriminalized adultery, and that time adultery was introduced under section 497, and there is very, very important judgment in the year 1951. There is a case which of Yusuf Abdul Aziz. In this case, what happened, he was charged with adultery, and he contended before the Bombay High Court that section 497 of Indian Penal Code is unconstitutional, as it contravene Article 14 and 15 of the Constitution, as it operate unequally between men and a woman by making only former men responsible for the adultery. So therefore, in this case, very beautiful observation which was made by the court, and the court, while upholding the constitutional validity of section 497, and the court made the observation that what led to this discrimination in this country is not the fact that the women had a sex different from that men, but that women in this country were so situated that special legislation was required in order to protect them. So it was from that point of view. So once we find that section 497 a position in law which takes a sympathetic and charitable view of the weakness in this country. So that is why recently in Joseph Shine case, the Supreme Court has decriminalized the adultery, because now we have reached, now our society has reached to that stage, now we are in a position to decriminalize adultery. Now, very, very important thing which were meant for the gender, that was Reformation movement. So, during the British rule in India, the status of the women, they was significantly influenced by two major movements, and there exists a social reform movement in the 19th century and a nationalist movement in the 20th century. So both these movements highlighted the matter of gender equality for the women, because there was at that time sati, ill treatment of widows, the prohibition of marriage of widow, polygamy, practice of parda, the prohibition of widow remarriage, the practice of temple prostitute, child marriage. So many laws they were introduced, many laws were created to combat societal ills such as slavery, sex slavery, child marriage restraint act, and also the law recognized Hindu women property rights and law allowing widows to remarry. So these are the just few examples which were so the law which were basically for the promotion and in the favor of the women. So during that time, the marriage during that period in the 19th century, because as we know now we have every religion, be it a Hindu, Muslim, Christian, Jew, Parsi, they have their own personal law for marriage, divorce, adoption, maintenance. So before the introduction of the Hindu Marriage Act 1955, polygamy was permissible, and it was practiced by majority of the Hindus and the Muslim. But the Christian community was the only community which adhered to the monogamy from the very beginning. It was only Christians and the Parsis and the Jew that do not practice polygamy. So they perform monogamous marriage. So in the early 19th century, so with the advancement along with the changing conditions of the world, condemnation of the polygamy was increased. So several legislatures, several provisions, they were passed, as well as several local laws, they made monogamy as a rule. So for the first time in the year 1946, Bombay Prevention of Hindu Bigamous Marriage Act declare a Hindu bigamous marriage as void. So prior to the Bombay Act 1946, a Hindu could marry for the second time, and particularly when it was preceded by the consent of the first wife and there was no objection to that such marriage were valid. And there was very important provision which was also introduced by the Britishers regarding Legal Practitioners Women Act. So, if we go back to the history, so the legal fraternity in India has for the first time recognized the importance of the female vakils or the pleaders to practice before the court of law by enacting the Legal Practitioners Women Act. So, prior to this enactment 1923, it was believed that the females are not allowed, that the gender who could plead anything for anyone in the court of law successfully, or even if they can, not in the subordinate courts, and only to some high court allowed them to do so. So it was only after this Legal Practitioner Act, the female, they were given the right to enroll themselves as a legal practitioner or to practice in the court of law. So since this enactment, the women begin getting enrolled as a legal practitioners. Now since we have tried to explore the gender dynamics during the British period, now since after the adoption of the constitution, now we will look into the gender dynamics in the Constituent Assembly. So it is very important for any discussion on law, gender and the constitution to go back and trace the history of making of the Indian Constitution. Though the history is long and there were only 15 women members in the Constituent Assembly. So the Constituent Assembly that drafted the Indian Constitution comprised 15 women members. Until recently, public memory had discarded the contribution or even the presence of these women. So the women members, they constitute just 5% of the Constituent Assembly, reflecting the hierarchical structure of the gender relation. So all these women, so there were around 15 women, they were the member of the drafting committee, and all these different 15 women, they had come from the different class, they had come from the different community, ethnicity. So these women, like other members, they come from the diverse background and they represented the views not only of the women but also socially deprived people from the different profession. So they were lawyers, these women, they were reformists, freedom fighters, and many of them belonged to the several women organizations, and they were also part of the feminist movement since 1917. So it is noteworthy that when the women, they were included in the several committees such as Hansa Mehta, she was one of the members, Amrit Kaur in the advisory committee, Durga Bai in the steering committee and rules committee. But these women, these 15 women, they were excluded from the drafting committee of the constitution. So however, despite the existing gender-based power dynamics, these women actively contributed to the formation of the constitution. That included forward-thinking measures relating to gender. So their role is frequently overlooked in the traditional narrative of the creation of the Indian Constitution. Now today's, we can witness the women excelling in every field, achieving and creating milestone, enjoying equal rights, performing equal responsibility efficiently. However, this became possible due to the vision, due to the foresight and the persistent effort which were made by these 15 women during the formation of the constitution. Now another significant aspect of gender justice, that the Indian obligation under the International Convention. So attempt for improving the status of the women and ensuring gender equality began at the global level with the establishment of the United Nations Declaration. And United Nations Declaration also spelled out equality and forbade the discrimination on any ground such as sex, race, religion. So equality of the rights of the women is the basic principle of the United Nations. So the international conventions such as Covenant on Economic, Social and the Cultural Rights and the Covenant on Civil and Political Rights. So these two covenants, they not only deal with the principle of non-discrimination on the basis of sex, but also there are number of provisions which are of great importance to the women. As an international convention or the multilateral treaties is a binding agreement between the countries. International conventions which we are talking, they are not laws as such, but they are international standards to which the national and the international legal system look for making new laws and interpreting, amending the existing laws. So these conventions which are adopted by the UN General Assembly, they are legally binding for the government, they have signed them. So the provisions of the Universal Declaration of the Human Rights falls mainly into the two categories. So the first set of the provisions which have been subsequently known as civil or the political right, these are also called first generation right, and the other is civil, political, economic, social and the cultural right, and these are called the second generation right. So these covenants, civil, economic and the cultural right and political rights, so these covenant interest the state parties to take deliberate, concrete and the target steps as clearly possible towards meeting the obligations which are recognized in the covenant without any discrimination on specific grounds. So in addition to these covenants, we will be also discussing International Bill of Rights. So this is another convention which protects the human rights of the women. So one of the most important convention which ensure gender equality in the society adopted by the UN is International Convention on the Elimination of all forms of discrimination against women, also known as International Bill of Rights. So CEDAW convention. So this convention is the first international instrument which explicitly addressing violence against women. So this convention provide us the framework for national and international action. So as far as our government have also taken the affirmative step in consonance with the CEDAW. I'll give you one case law. I will explain with the help of one case law in the case of Apparel Export Promotion Council versus A.K. Chopra. So this case was decided in the year 1999. So the issue which was involved in this case complained of the sexual harassment in the workplace. So a female employee alleged that her supervisor had persistently made unwelcome sexual advances towards her, but Mr. Chopra attempted to sexually harass a secretary while working as an executive for the Apparel Export Promotion Council. He was fired from his position. Then he sued the council alleging that since he did not actually commit any sexual act, so therefore it does not amount to harassment. So the Supreme Court in this case, while using the provision, while using the CEDAW convention, made a major case law and also defined the meaning of the sexual harassment along lines of the intimidation. So the court was explicit in noting that the parliament had not clarified the definition of the sexual harassment, but since the government has ratified CEDAW, and so therefore this is the duty of the domestic courts. So therefore the domestic courts, they are bound to consider such cases. So in the absence of the legislative guidance, so the court promulgated its own standard to be in conformity with the CEDAW. Now, since we have so far discussed the status of the gender justice or the obligation under the international conventions or the covenant, now we can also find certain provision for female equality in the Indian Constitution. So where the Constitution is written, and the framers of the Constitution, they were aware of this problem that the female, they face discrimination. So therefore, they also made special provision for them. So the basic proposition of gender equality has been embodied in the Indian Constitution, in the directive principle of the state policy, in the fundamental rights, in the preamble, and also include the provision for equal rights for women and men. So if we talk about right to equality is contained under Article 14 to 18 of the Indian Constitution. So these articles brief that how every individual is equal in front of the law and nobody can be discriminated on the basis of their race, caste, gender or place of birth. Since the equality provision is thoroughly contained under which provides equal protection or equality before law and equal protection before law, even then, in spite of this fact, Article 15(3), which allows the government to frame special laws regarding the protection of the women and children. So not only for the protection of the women and children, but also in the favor of the women and children. Further, Article 16, which provides that no citizen shall, on the ground only of religion, race, caste, sex, decent place of birth, residence or any of them, be ineligible for or discriminated against in respect any employment or office under the state. So it is against the law to discriminate against people based on their religious belief, ethnicity, class or gender. So as a result, the state prioritize women and children as a group that deserve special attention. Now further, very significant provision, fundamental right, which was introduced in the year 2009 and made right to education a fundamental right by 86th Amendment. So Article 21A was inserted in the Constitution to provide free and compulsory education to all the children under the age group of 6 to 14 years as a fundamental right in such a manner as the state may by law determine. So if we look at this provision is technically available to both the gender. This is gender positive provision. But if we look at the reality in the rural area is different. In case if a family consists of son and a daughter, so they would prefer to educate son rather than the daughter. And now another provision which is again very, very important, that is Article 23. So fundamental rights contained under Part 3, and there are only two prohibitions in our Constitution: prohibition of trafficking in human beings and forced labor is a provision under Article 23 of the Constitution. And this is the fundamental right of every citizen of India. So according to this article, if a person indulge in human trafficking or any type of the forced labor like beggar, he will be punished by the court. Similarly, Devdasi was a kind of the forced labor of young women, though Article 23 of the Indian Constitution does not explicitly mention about the Devdasi, but this was the practice where the young girls, they were given away to the certain temples. And Article 23 of the Indian Constitution also deals with activities like exploiting others, paying less than what they deserve, bonded labor, forced labor are completely banned. So therefore, if anyone contravene these provisions, he or she shall face the serious action. Now, further, Article 24 of the Indian Constitution. So, Article 24, no child below the age of 14 years shall be employed in any work, any factory or mine or engaged in any other hazardous employment. So, again I would say that this provision is gender positive discrimination. Then under the Child Marriage Prohibition and the Regulation Act 1986, the engagement of the children up to 14 years was prohibited in certain hazardous occupation and processes, and to regulate the condition of the work, children in other employments. Since now the government has also enacted Child Labour Prohibition and Regulation Amendment Act 2016, which came into force in the year 2016, and the Amended Act covers the complete prohibition on employment or the work of the children below 14 years of age in all the occupation and the processes. Because this provision linking the age of prohibition of employment with the age of free and compulsory education, because on one side we are providing the children up to 14 years free and compulsory education, so there was the need to put the complete prohibition on employment or the work of the children before 14 years, then only we can implement Article 21A, and we can only provide the free and the compulsory education up to 14 years of age. Then further, directive principle, Article 39A, which talks about the right of every citizen in the country to have adequate means of livelihood irrespective of their gender. So this was a gender neutral provision, Article 39A, which is essentially relating to the employment. As we know that under Article 39A of the Constitution, various schemes they have been introduced by the government to provide adequate means of livelihood to the citizen of country, such as Pradhan Mantri Shram Yogi Mandhan Yojana, Pradhan Mantri Rozgar Protsahan Yojana, Aam Aadmi Bima Yojana, Grant in Aid scheme for the welfare of the women to NGOs. So these are the few examples which promote livelihood. Then further, Article 39D. So the Constitution of India guarantees equal pay for equal work for both men and the women under Article 39D of the Indian Constitution. But if you look at the data, if you see that there is a huge gender pay gap, a women being paid less than men even when both are performing the same role in a company. Women employees in India earn less than their male counterpart on every step up in their career, as reflected by widening the gender pay gap as a women rise up the organization hierarchy. So ensuring just working condition and maternity relief holds paramount importance for the well-being of the citizen and the overall societal fabric. So just working condition encompass fair wages, reasonable hours, safe environment, ensuring the dignity and the health of the workers. So these conditions not only enhance the productivity and morale of the workforce, but also uphold the fundamental human rights and the dignity of the individual. Next, Article 42, which deals with the maternity relief. Maternity relief, on the other hand, is a crucial element of gender equality and social justice, which provides support to the pregnant and the nursing women in the workplace, acknowledges their dual role as a contributor to the economy and caregiver for the next generation. So these relief not only safeguard the health and the well-being of the mother during the vulnerable period, but also lays the foundation for the healthier children and more inclusive society. Now we can see that now the concept of paternity leave has also been introduced. It is not only for the men. Basically, paternity leave is for the child, because the father remains with the child. Psychologically, bonding develop between the newborn and the father. Now we will try to look into our personal laws. We will try to look into the dynamics of the gender justice with the help of the personal laws. As I already said, that the individuals, they are governed by the personal laws, but we have a Special Marriage Act. If you look at the Special Marriage Act, it contains the identical provision for men and the women, such as divorce, maintenance, marriage, etc. But if you look at our classical law, under classical law, the maintenance, the obligation to pay maintenance, generally the onus was on the husband. Husband obligation to financially support the wife during marriage and also on the divorce or the separation. But after the introduction of the Hindu Marriage Act 1955, but this disqualification to pay maintenance by the husband, it was removed. Now this disqualification put the women at par with men, such as maintenance under Hindu code is a gender neutral provision which made both the husband and the wife liable. Thank you.